get the difference between the judicial branch and the other more political branches. In order for us to maintain our judicial independence, we need people to understand why that's important, why you can't just remove a judge because you disagree with their ruling. The more that people have that interaction, the personal interaction with folks who sit as part of our judiciary, they get a better understanding, and I think a better respect for the process, which is so important. I mean, I think, I'm going to get on my soapbox here, but I think our whole society relies on respect for the judiciary, because you have to have some trust at some level that if something goes wrong, that the judiciary, when the case goes there, is going to do the right thing. Because if you don't believe that, then why are you going to follow the rules? Why is anybody going to follow the rules if they don't think? Okay, thanks, Rich. So my bio was emailed out and on the Carson Now little blurb about this event, but let me just quickly tell you a little bit about my background. So I grew up in New York and New Jersey. Went to college at the University of Pennsylvania in Philadelphia, and then law school at the University of Virginia. I came to Nevada in 1989, right after law school. Now you know how old I am. For a 2-year clerkship that I had with one of our then US district judges, now retired, Judge Philip Pro. And so I figured, well, at the time, I'd never been further west than Chicago in my whole life, only on the East Coast. And I thought, well, I could go anywhere for 2 years. And so 32 years later, here I am, still in Nevada. I was in Las Vegas until a couple years ago when I moved up to Carson City after getting elected to the Nevada Supreme Court. In between there, after my clerkship, I was in private practice. I did commercial litigation and employment law, primarily with a couple of large firms, and went on the district court bench after being appointed in the summer of 2007. Got elected in 2008 and again in 2014, and then ran for the Nevada Supreme Court in 2018. And I had 5 opponents that year and managed to come out on top in the end and won that contested election. So I started my service on the Nevada Supreme Court in January of 2019. So let's talk quickly. We were talking earlier, if any of you were around and listening, about the general setup of our Nevada Supreme Court. So we have 7 members of our Supreme Court. Sometimes people don't even know that. Many people know we have 9 justices on the US Supreme Court. We have 7 on our Nevada Supreme Court. And since I've joined the court in 2019, we are majority female. That is, we have 4 women and 3 men on our court. And this is the 3rd year that we've had that female majority on our court. Next year, one of our panels of 3 justices, I'll explain more about that in a minute, is going to be all female. So that'll be the first time that we've had an all female panel on our Nevada Supreme Court. So that's exciting progress that we're making. And I hope that we're setting good examples and encouraging more young folks to pursue the law as a profession. Also, one of the things that came up earlier, all of the justices on our Nevada Supreme Court, we are elected for 6-year terms. We do run statewide, so we don't have like particular local districts that we come from. We all run, and everyone in the state of Nevada can vote for us and for those 6-year terms. And Sandra was mentioning this a little while ago. We run in nonpartisan races, so the election ballots don't identify what our party affiliation is. If we have one, we all run nonpartisan. And that's because as judges, we're not supposed to be running based on our own personal policy views, and we're not supposed to be deciding as judges based on our own personal policy views. Our job is to enforce our Constitution and laws, and to rule on the cases based on the law. So it's not up to us to say if we think a law passed by the Nevada legislature was a good law or a bad law, or if we agree with it or not, or if we think it doesn't really make sense. That's not up to us. The legislature gets to make the laws, but we have to interpret them and apply them to the facts of the specific cases before us. Or in areas where there aren't statutes governing, then we look at various case law, and those are the common law areas, and we have to decide the rule in that area based on our history of law. Because of the position that I have as a judge, I can't comment, for example, on political issues. I can't endorse any candidate in any race, a judicial race or a political race. And I can't talk about anything that may come up as an issue before our court, or anything that is currently pending before our court and hasn't been decided yet. I'm not allowed to commit myself to rule in a particular way on an issue, and we can't discuss any issues that are pending before us or that may come before us. All right. So the court, first, our Nevada Supreme Court building is located on our Capitol grounds here in Carson City, right between the legislative building and the Capitol building, where the governor and other executive offices are. And we do also have a Supreme Court, an appellate courts building in Las Vegas as well. So 5 of the 7 justices, including myself, have our chambers here at the building in Carson City. And what does that mean, our chambers? Well, we have not only our office, but our assistant and 2 law clerks. So there's offices for the 2 law clerks and assistants attached to our chambers here in Carson City. So 5 of us have that big chambers here, and 2 of the justices, that is Justice Silver and Justice Pickering, they have their chambers located in the Las Vegas courthouse. We all travel statewide. We have cases that we have arguments sometimes in Las Vegas and sometimes here in Carson City. And we've even been known to have arguments in other places on the road when we're able to get out and about more than we are right now in the current circumstances. But again, the only 2 justices that aren't with their chambers here in Carson City are Justice Silver and Justice Pickering. But the other 5 of us have a visiting office in Las Vegas, and Justice Silver and Justice Pickering have a visiting office in the building in Carson City. We also have the Court of Appeals, which has 3 judges on the Court of Appeals. 2 of those judges are based in Las Vegas, and 1 is based up here in Carson City. One thing that Rich mentioned, which I think is misunderstood a lot. So we have our 7 justices on the Supreme Court, but under our Constitution, the Chief Justice seat rotates among the members of the court. It's not like the US Supreme Court, where a particular nominee is confirmed specifically to be Chief Justice. On our court, it's based on being in the last 2 years of your current term. So, you know, Rich, actually, it would be helpful if you could share that list that you've got while I talk about this. So Rich made a list of the current members of the Nevada Supreme Court, and in parentheses there is the year that each of those justices are up for election. So next year, 2022, you can see that Justice James Hardesty in Seat A and Justice Ron Paragary in Seat E are both up next year. So they're both currently in their 5th year of their current term. Next year, they'll be in the 6th year of their 6-year term. So, okay, Rich, thank you. So what happens, so originally we only had 3 justices on the Nevada Supreme Court, and the Nevada Constitution said the justice with the most seniority in their current term sits as the chief. So when there were only 3, then that particular one of the 3 who was in their last 2 years would be the chief. Well, now we have 7. So there's either 2 or 3 justices that are in the last 2 years of their term at any given time. What ends up happening as a practical matter is those justices just reach an agreement about how they're going to work it out. So for example, this year, Justice Hardesty is our Chief Justice. Next year, Justice Paragary will be our Chief Justice. They worked it out between them to have 1 this year and 1 next year. In the event that the justices couldn't agree, then they could draw lots or something like that. In my schedule, because I was elected in 2018, that year there's 3 justices that were on the ballot. So the 3 of us will need to work out who's going to be chief during the 2023 and 2024 years. And we'll deal with that later. That's not an issue. For now, the prior justices who previously were on the court worked it out a couple of different ways, and we'll need to deal with that when we get there. We also have panels. I mentioned a panel of 3 a little while ago. So some cases at the court get assigned to the whole court to decide. Those are called en banc cases. So usually those are the, I guess, the biggest issues, the most sort of groundbreaking that haven't been addressed by our court before. And so they'll get routed to the full court en banc. There are also cases that get assigned to panels of 3. Each year we have a northern panel and a southern panel, and they each have 3 justices. The chief doesn't sit on a panel because the chief has all kinds of administrative duties that they do in addition to their work on the en banc court. So, but what I think most people don't realize is that the panels change every year, and it's actually a random selection that we do every year in around March or April. We do literally like picking pieces of paper out with all the different iterations that are possible of the justices for which one is going to be the northern panel and which one and who's going to sit on the southern panel. So those assignments, contrary to popular belief, have nothing to do with where our particular chambers is located. In other words, Justice Silver and Justice Pickering may sit in the Las Vegas courthouse, but they're not necessarily going to be on the southern panel. I'm not necessarily going to be on the northern panel. The panels change every year based on that random selection. And then let's talk briefly about the Court of Appeals then. So we have, as I mentioned, 3 judges on the Court of Appeals and 7 justices on the Nevada Supreme Court. The way our appellate courts are set up, all appeals from the district court get filed with the Nevada Supreme Court in the Nevada Supreme Court clerk's office. And then some of them, approximately a third of the appeals that get filed with us, get pushed down by us to be initially resolved by the Court of Appeals rather than the Nevada Supreme Court. And if the Court of Appeals, or once the Court of Appeals rules on a case, the parties can seek to have the Supreme Court review it, but that's discretionary with the court, and they have to establish that there's some major issue or inconsistency with prior law that would warrant our court to look at it, and we don't grant very many of those petitions. Similarly, if a panel of our court decides on a case, the parties can ask the full court to review it if they want to. And again, that would only happen if there's an issue that would warrant the full court to get involved, if there's some inconsistency in case law or things of that nature that would warrant the full court getting involved. Obviously, we do have a heavy caseload at our court, and having the Court of Appeals and having some cases being addressed by panels at our court helps us to be able to address the volume that we have on the cases before us. I should say also that when we do have arguments on the cases before us, you can watch them. Well, normally you can come down to the court and watch them if you want to, but also they are live streamed on our court website. So if you are aware that there's an interesting case coming up for argument, maybe you see in the newspaper or what have you, that an interesting argument is coming up, on the Nevada Courts website, which is nvcourts.gov/Supreme. If you go to the page there, on the right side, there'll be a place where you can click to watch the live stream of our arguments while they're actually going on. If you don't get to watch it while it's actually happening, we do save the audio recordings. We don't save the video, I guess that takes up too much space, but we do have the audio recordings of our arguments archived on our website as well. So if you read about some recent argument in a case that you're interested in, you can go to the court's website, find it, and listen to those arguments. So let me, before I go on and talk about some of the interesting cases that I've gotten to work on at the court, I just want to explain a little bit about the difference between, well, I guess explain what we do as the Supreme Court, because not everyone necessarily understands what it means to be the Supreme Court. So the district courts in our state are the trial courts. So that's where if you get called for jury duty, you're going to district court. That's where trials happen, witnesses testify, exhibits get offered and admitted, and the judges rule on evidentiary matters. So cases are going to get resolved in that court. Either they go to trial and have a final judgment, or by virtue of some motion practice, perhaps the judge has ruled for one party or the other, and a final judgment gets entered based on that. That all happens at the district courts, which are our trial courts. Appeals from those cases are what comes up to us. So that means if the parties want to argue that there were legal rulings made by the judge that were incorrect, or the jury engaged in some misconduct, attorney engaged in some misconduct, those sorts of things where they want to challenge the final judgment that happened in the district court, they can bring those cases up to us in the Supreme Court. So they file written briefs where they make legal arguments about why what happened at the district court was incorrect, either because of a legal issue that was ruled on incorrectly, or the evidence doesn't support the factual decisions that were made either by the judge or the jury. Now, we get appeals from all kinds of different cases. We get civil cases, which are lawsuits between parties for money usually, although there can be other sorts of relief. We get appeals in criminal cases. We also get appeals in family court cases. We also hear probate and guardianship cases. We hear appeals from rulings of the various administrative agencies, everything from the DMV to the Public Utilities Commission, as well as cases where someone's appealing from like a city council or county commission issue. Usually those go first to district court and then would come up to us. So we have a wide range of cases that we hear at the Supreme Court. But when they file briefs with us, then they give us the transcripts of what happened below. So we'd have, if it went to trial, we'd get a transcript of the trial. If there were court hearings that are being challenged, we'd get a transcript of the hearing. They'd give us copies of the pertinent exhibits and things like that. And all that becomes part of the record that we have in addition to the briefs that the parties give us. Most cases, we end up ruling based on those briefs that they file and the record, although we do have arguments, as I mentioned, on some cases. The vast majority of cases we rule on without argument, but if we feel like we have some questions we need to ask, some issues we need to clarify, where it would be helpful to get the attorneys into court to cover those issues, then we set it for oral argument. Most of the arguments are 30 minutes. So each side in that case would get 15 minutes of time to present their side of the case and respond to our questions. Sometimes there are cases that we give more time for, such as a 60-minute argument where each side would have 30 minutes. But what we don't have, because we're doing appeals, we don't have witnesses coming and testifying in front of us as a Supreme Court, or we don't have exhibits being offered up and things like that. We're ruling based on the record as it comes to us from the court that they are appealing from. So that's sort of the general background of what we do. Let me take just a few minutes and talk about a few interesting cases that I've gotten to work on, and then I'll take some questions and do my best to answer them if I can. So first, especially those of you who are up here in Northern Nevada are probably aware of a pending criminal case against Mr. Martinez Guzman, who is charged with murders and burglaries in January of 2019, both in Reno and in Douglas County. As you know, Reno's in Washoe County as opposed to Douglas County, and they have different district courts, as well as he's also charged with possessing stolen property here in Carson City. So in that case, the district attorneys from the three different jurisdictions, Washoe County, Carson City, and Douglas County, worked together on that case, and they decided to have Washoe County take the lead and presented all of those charges to a Washoe County grand jury. So the grand jury returned a true bill and brought charges based on those events that I mentioned. The defendant, Mr. Martinez Guzman, through his counsel, filed a motion to dismiss 4 of the charges that related to the murder and burglary charges that arose from Douglas County, arguing that the Washoe County grand jury wasn't the proper place, that those charges would have to be brought in Douglas County. The district court reviewed that, and the district court initially ruled that no, that the grand jury for Washoe County has statewide jurisdiction and can consider crimes from anywhere in the state. That came up before us, and we looked at the applicable law governing grand jury authority and governing what's called venue of cases. That is, there are statutes that determine where particular cases need to be brought, which courts are the appropriate courts to bring cases. And we ended up holding that there is not statewide jurisdiction for the particular grand jury there in Washoe County, that instead the court has to look at the particular venue statutes that govern where particular charges need to be brought, what's the appropriate location, and only if those charges could be brought in Washoe County can that county's grand jury appropriately consider that matter and bring the charges. So in that case, because the district court had held it was statewide jurisdiction, we sent it back then to that district court to then analyze, based on the evidence presented, how the venue statutes would apply. Can these charges, is there a sufficient connection between those charges and Washoe County to warrant the Washoe County grand jury to be able to bring return a true bill on those charges, investigate those charges and bring them. Now, that district court judge subsequently considered the evidence and the statutes and ruled that, yes, there is a sufficient connection. That ruling is currently back on appeal before us now, so I can't talk about what we're going to do on that any further. But the prior case opinion that that I authored and that the court issued told the court that those are the venue statutes that they need to look at. And well, I better not get into the details for now, but maybe next year we can talk more about what happens down the road on those issues. But there are crimes that he allegedly committed, included taking a gun from a home in Reno, where he ended up later killing the two occupants of that home. But that's the gun that he used allegedly in the two Douglas County murders that are charged. So the question will be about whether there's sufficient connection in those charges to justify bringing them all in Washoe County. You likely have also heard multiple times about the next case that I'm going to talk about, which was the case involving the requirement of a 2/3 vote of the legislature for taxes. The first time that case came up to us, it was an issue about counsel, that is, among the named parties. So let me back up. The Republican senators from our state legislature filed a suit against Senate Majority Leader Canizero, the Secretary of the Senate, the Department of Taxation, the governor, the lieutenant governor, and some other particular defendants who were involved in these laws, challenging the approval of certain tax extensions. So the Legislative Counsel Bureau has a legal division which is authorized to represent the legislature and to defend the constitutionality of laws that are passed by the legislature. So the LCB legal department attorneys appeared to represent the legislative defendants, and specifically the Senate Majority Leader and the Secretary of the Senate, to defend the constitutionality of those laws. The Republican senators who were the plaintiffs moved to disqualify those attorneys from representing them, and argued that, hey, the LCB attorneys also advise us during the legislature, and so because they're also our attorneys, they can't be against us in this case. There's rules governing conflicts of interest that say an attorney can't be involved in a case and be adversary of another existing client. So that case came up before us to decide, is that a conflict of interest? And in that case, I said, well, our court said that in that case, these attorneys from the Legislative Counsel Bureau represent the legislature as an institution. It's the entity that's their client, not individual members of the legislature per se. And so we held that in that circumstance that the individual senators who were seeking to declare those laws unconstitutional, that they individually weren't acting on behalf of the legislature in that case, and they weren't clients of the LCB in that circumstance. So we said that the Legislative Counsel Bureau attorneys could represent the Senate Majority Leader and the Secretary of the Senate, who were sued only in their official capacities based on their positions that require them to sign the laws that are passed by the legislature. The other issue that came up more recently that you're probably more familiar with was the merits of the case itself. That is, whether the laws that were passed were constitutional. So as I mentioned, we have a provision in our Nevada Constitution that requires a 2/3 vote of each house of the legislature to pass a bill which creates, generates, or increases any public revenue in any form. Okay, so we had the DMV $1 fee, as well as an increase in the modified business tax, which had previously been approved by prior sessions of the legislature, but they were supposed to sunset at a certain point. So in 2019, in the legislature, they voted to extend those taxes. So rather than either being eliminated or decreasing, depending on which of the two taxes we're talking about, they would continue the same as they had been before, rather than reducing or being eliminated. So the argument, sorry, I just caught my cat in the corner of my screen. So the argument is whether by extending those taxes that were otherwise set to be eliminated, that creates, generates, or increases any public revenue in any form. The legislature, through the Legislative Counsel Bureau, argued that it didn't increase revenue because the tax rate was going to stay the same as what it had been before. It had never gotten reduced, so if they were keeping it the same, that it wasn't an increase. Our court unanimously held otherwise, and we looked at it and said that if this 2019 bill extending those taxes hadn't been passed, then that 7 million, I think, of revenue wouldn't have been received. And by passing this bill, that in fact generated or increased public revenue in accordance with the constitutional provision. And therefore, it did have to have a 2/3 of each house. And because it was one short of the 2/3 required in the state Senate, it was therefore not passed constitutionally and was void. And so I know you're aware of current efforts by the legislature to figure out how to refund the taxes that were collected during the time period before the court had ruled on that. I'm going to talk quickly about a couple of cases that you've heard about. Maybe I'll kind of summarize it so we have time for some questions. So there's been some issues about bail that have come before the court in the last couple of years. First, in 2020, we ruled in a case called the Valdez-Jimenez case. And we said that, well, a defendant under our state constitution has the right to reasonable bail. And so what we said is, under that circumstance, if bail is going to be set in an amount that that particular person charged, that defendant cannot afford, then there has to be due process protections in place for that to occur. So particularly, we said there has to be, after they get arrested, a prompt, individualized hearing where they're allowed to present evidence and arguments about what should happen, and that the main concern in establishing bail is whether they are likely going to come back for future hearings or whether they present a danger to the community. And the burden is on the state, the prosecutor, to show by clear and convincing evidence that bail has to be established to ensure their presence or protect the safety of the community. And if the court decides that bail has to be set rather than other non-monetary conditions such as house arrest, for example, or checking in regularly, other conditions like that, if bail is going to be set, then the court has to make specific findings on the record and has to consider the financial resources that that particular defendant has. So that what we don't have is people who have monetary means available to them able to bail out, whereas those who are simply don't have that kind of funds available, not able to do so, which is not based on the nature of the case or their potential danger to the community. There were some laws passed by the legislature this past session to follow up on what we said and impose some specific requirements, but I suspect that there's going to be some more litigation about those issues and exact the parameters of how all that works. So I can't say much more about that, except that we recognize that the burden has to be on the prosecutor to show why someone has to be kept in custody rather than released, and they have to have an opportunity to present evidence in a prompt hearing to do so. Now, the only exception to that is in murder cases. We had another case earlier this year, the Seawall case. And so under Nevada Constitution and statutes, when there's a murder case, they don't have a right to bail if the proof is evident or presumption great that this person committed this crime that they're charged with. So that's an exception there. Now, in this particular case that I had, there was a female victim who was found dead from a gunshot wound. And well, they ended up not being able to solve the problem. So the case went cold and unsolved for a while. Well, eventually they got the DNA from the semen and were able to run it through the system, and it matched up to this Mr. Seawall, who then they talked to him about it. He made sort of a confession of sorts, although he said it was an accident that the gun went off. But it was found that there was a violation of his Miranda rights, and the confession was suppressed. So that no longer was going to be admissible evidence when it came time for trial. So after that ruling was made, Mr. Seawall's attorneys then filed a motion saying he should be allowed to be released on bail. He shouldn't be held in custody. And the evidence that the state had against him at that point, without being able to use the confession because that's been ruled inadmissible. So what they had was his semen on her, and there was evidence that a particular type of gun had been used, but there were several different calibers that were possibilities and several different brands. There was evidence that Mr. Seawall, at the time of the offense, owned a gun that would fall within those categories. But it wasn't like where you see sometimes where there's testing that specifically matches up to that particular gun. That hadn't happened. In fact, I don't think they had his gun and hadn't been able to examine it. So we held in that case that just the fact that his semen is on her and he owned a type of gun that wouldn't be excluded was not enough evidence to show the proof is evident or presumption great. And therefore, he was entitled to have bail considered. He couldn't just be held without bail under that statute. So we sent it back to the district court for the court to consider in accordance with what we said in the other case. So in any event, in that case, we said that wasn't sufficient evidence. I just want to briefly mention one more case, which is the Anderson case from the fall of 2019. So in general, you have a right to a trial by jury anytime you are charged with a serious offense. And generally, a case that only has a maximum sentence of up to 6 months is presumed to not be such a serious case and not give you the right to a jury trial. It's considered a petty offense. Well, the particular defendant in this case was charged with a misdemeanor offense of battery domestic violence. And it's only punishable by up to 6 months. So he was not given a jury trial when he came up on his misdemeanor case in the municipal court. In 2015, though, our Nevada legislature passed a law that prohibited ownership of firearms and in fact made it a crime for someone who's been convicted of even a misdemeanor battery domestic violence to have a firearm. And of course, that's being used to deprive someone of their Second Amendment rights to have a weapon. So in this case, we held that even though it's only punishable by up to 6 months, the fact that our state legislature has determined that you're also going to lose your ability and right to have a weapon, that shows that the legislature considers this to be a serious offense, and therefore there has to be a jury trial even for a misdemeanor battery domestic violence case. So in the time since then, our municipal courts and justice courts where misdemeanor cases are tried have been scrambling to put in place a process for them to be able to have jury trials on these cases, because most misdemeanors do not have jury trials and those courts generally don't conduct jury trials. I also wanted to mention, I can't get into the merits of it, but there's a case pending before us now about the separation of powers provision of our Nevada Constitution, specifically the part of our state constitution that lays out the 3 different branches of our state government, of course, executive, legislative, and judicial, and says that someone who is carrying out the functions of one of those branches can't perform functions in the other branches. I'm paraphrasing, I'm not quoting the exact language of the Constitution. In one criminal case, a misdemeanor case in Las Vegas, a gentleman was convicted of a DUI offense, and which was a misdemeanor in that case, went up on appeal to the state district court. The district court, hope I'm not going to confuse anyone, hears appeals from municipal court or justice courts. And on that appeal, the court held that because the prosecuting attorney in that case was Melanie Scheibel, who's also a state senator, that she couldn't be a legislator, state senator, and also a prosecutor, because a prosecutor, the holding goes, is part of the executive branch, and she's improperly participating in two branches, and therefore dismissed the criminal charge. That case is up before us for argument on September 9th in Las Vegas at 1:30 in the afternoon. I mentioned earlier that you can watch our arguments live, so you'll be able to watch that one live streaming on our website, or go back and listen to it later. I think I'm going to leave it there then, so we have time for some questions. I guess I went on a little longer than I anticipated. I hope you find some of those cases interesting, and I hope that you understood my explanations. Do my best.
I'd like to ask you about immigration. You may know the Constitution doesn't mention immigration, although it does mention naturalization. And last time I checked, there was some dicta from the U.S. Supreme Court saying, well, if it says naturalization, they meant it to include immigration, but that wasn't the way things were before the opening of Ellis Island in 1892. If you came in prior to that to New York Harbor, you'd dock at what's now Battery Park, and you would have been met by a state immigration authority, and that had been the status quo. And I don't know what changed, but as far as I know, nobody has actually changed the Constitution. If an immigration case came before you, would you say, oh no, that's a federal matter? Or would you say, well, is it a federal matter? Does the 10th Amendment apply here?
Well, so this is where it gets frustrating, right? So the first thing I have to say is I can't tell you what I would do on any case that comes before me. And so it would depend on the particular issues raised about whether it would be appropriately something for the state court to be considered as opposed to a federal issue. So I'm sorry that I can't really offer an opinion on that.
Well, I'm being a provocateur here.
I understand.
So when you have let's say you're not en banc, when you're in a 3-judge panel and you live here, but you're in Las Vegas. So you do have what did you call it? A visiting office. Was that what you? Well,
yes, I have a visiting chambers there, which is effectively an office I have in the building down there.
So you have some staff that work there, I assume.
The court has staff there, but my assistant and my law clerks are based up here. So, but we do get, like, if we're having en banc arguments down in Las Vegas, then we also have an assistant who's there to help us with anything we need during those days that we're down there to help us out as needed.
Okay.
Richard has a question.
He usually writes his questions down.
Okay. Do some judges specialize in certain subject areas? Like my ex-girlfriend's dad on the Supreme Court, he specialized in marriage and divorce law in Hungary. If so, what would your specialty area be? Okay, interesting. Actually, in our court, that we don't have specialty areas among the justices on our court. We all deal with cases that deal with all of the various legal areas that we deal with. So, like, some of us may, just because of cases we've worked on, become a little more knowledgeable about the issues on some cases. But I should say that our cases get randomly assigned within the court. So, like, if I like a particular kind of case, I can't say, hey, chief, give me the cases with that issue. That's not how they get assigned. Well, they get randomly assigned to get worked up, researched by the law clerks, and bench memos prepared. And then if the chambers that worked up the case is in the majority, once we consider it and vote on it, then that chambers will go ahead and draft the decision on it. If that judge is not in the majority, if they're dissenting, then potentially a different justice would end up being responsible for writing either the order or the opinion on that. I should say, just to clarify that also, our published opinions are the decisions that we make that have precedential value. That is, that they're mandatory precedent throughout the state of Nevada, and all Nevada courts have to follow those. And so in those decisions, we have to be careful to explain the facts of the case and our entire analysis that gets us to the conclusion that we reach. In contrast, most cases that we decide by an order. And while the order is open to the public and it is available to be read, of course, it doesn't have a precedential value. It's not mandatory. We focus our decision then on the particular facts of the case before us. We more summarily describe what the case is about and the facts that we're relying on and ruling on that. And so, just as an aside, that's the difference between orders and opinions. I think we generally have about 100 or so opinions each year. We're working on trying to get some more of those to help give guidance to the courts in our state.
So I think I hear from a lot of people that there's an assumption that if I feel I've been wronged or some wrong has happened and I can pay for an attorney, that I'm automatically going to go into a courtroom and a judge is going to accept my case. Can you talk a little bit about like standing and merit, how a case actually gets into court?
Sure, yes. So to file a case in court, as Sandra mentioned, you have to have something called standing, which means that you have to have been particularly impacted by whatever it is you're complaining about, and an interest, a direct, specific interest in the outcome of the case. And you have to have a specific interest. So it's one thing if a law is passed that specifically is governing your particular profession, for example, or your kind of business or something like that, then you're going to have standing. But you can't just go complain about things in court. Courts deal with specific cases between parties that are adverse to each other, and there has to be an actual ripe legal issue between the parties for a court to be able to address that. That's what makes it justiciable, is the word that we use, and that's true in state or federal court. There were, some kinds of cases where we can find an issue of sufficient importance to allow a challenge to certain laws, and that's specific to our Nevada jurisprudence. We do allow some more challenges than, for example, federal courts do. But generally, you have to have a specific interest and specific harm to bring a lawsuit.
I'm wondering if you can speak a little bit about the judicial issues that are going through right now about the theft of Indian and Native lands, and how the courts, what you have to go through in order to handle that. I know when I'm advocating for a child, I have to use Indian law.
So I haven't addressed any cases specifically dealing with Indian law, and I think that those are generally federal issues.
Yes.
I see Sandra nodding,
Yes.
which gives me a good feeling. I know that there was, and again, I'm not offering any opinions about it. I know one of the U.S. Supreme Court decisions this last term involved issues about being able to arrest folks while on Native American lands, and but I haven't had to specifically deal with the impacts of that on our Supreme Court. That's interesting though, but I think generally those are federal issues. One other thing that members of our court do is we also sit on the state pardons board. So the pardons board is made up of the governor, the state attorney general, and all 7 justices.
Wow.
And so we sit as the pardons board, and until this last election, some changes were made in there. It used to be that the governor on the pardons board had effectively veto power. So in other words, even if the 8 others on the pardons board voted to grant a pardon, if the governor said no, it was no. That's no longer the case. Now we all have an equal vote on the pardons board. Additionally, we're now required to have pardons board hearings at least 4 times a year. I guess there were some years that the board had only met 1 or 2 times. And there's been a backlog, frankly, of applications for the pardons board because we've been short-staffed, which is part of the problem, and then there weren't regular meetings happening. It wasn't being prioritized sometimes. But we now are meeting at least 4 times a year going forward. So, and just to quickly explain what we do in a pardons board. So there are 2 kinds of cases that we hear. One kind is inmate cases. That is, people who are currently in custody in the prison system who are seeking some kind of relief. Usually what they're seeking is to get eligible for parole, like now or sooner than they would otherwise be under their sentence structure. So it may be someone who's got a sentence of life without possibility of parole, and now they've been in custody for 25, 30 or more years, and they're trying to show that they should at least be able to parole out. Or somebody who's got parole eligibility after 40 years and they're trying to get it moved up. Maybe it's 25 years, things like that. They also can ask for a commutation of the remainder of their sentence. That is, to make a determination that the time they served is sufficient and they've now completed serving their sentence. Those are not as common as the parole eligibility ones that we see from the inmate cases. The other type of case we see are community cases. Those are people who've done serving their sentence, they're out in the community, and they're now seeking a pardon, which effectively like undoes and wipes out their conviction for the particular crime for which they're seeking a pardon. And then those pardons can be unconditional, which means they get all of their rights back, all of their civil rights, including sitting on a jury and right to have firearms. Sometimes, though, what we grant is a conditional pardon. That is, they get pardoned for the underlying offense, but we still keep in place the prohibition on firearm ownership. And that can happen if some members of the board have some concern about whether that person appropriately should be having firearms or not. But usually the cases that we see on pardons are cases that are years down the road, and obviously we're looking for people who show that they have turned their life around, they are good citizens, they are complying with the law, they're contributing to their community. And really, you need to make a strong showing, because it's characterized as an act of grace, and it's not common, obviously. There's few cases that come up where we do grant pardons like that. Occasionally, there can be a case where there's a concern about whether somebody's conviction was a wrongful conviction, and that may be a circumstance that could warrant a pardon as well. before I came on the Supreme Court, when I was a district judge, I had before me a case involving defendant named Fred Steese, who had been convicted of a murder more than 20 years earlier. And there was evidence presented that he not only had not committed that murder, but he was actually in another state at the time of the murder. And that was shown through a combination of phone records and other records, as well as witnesses and other evidence that was presented. And I found in that case that he was actually innocent of that murder. And he ended up, he was later brought before, after I found that, it's a little complicated because after I found that, the state still could have elected to retry him and were saying they were going to do that. And he ended up taking what's called an Alford plea to a second-degree murder charge, which means he didn't admit he was guilty, but, you know, agreed to the plea. And he had already served more than the 20 years required. So effectively, by agreeing to that, he immediately would be done with his sentence and got released. And he later came before the Pardons Board, though, this was several years back when Governor Sandoval was still governor, and all 7 Nevada Supreme Court justices and Governor Sandoval voted at that time to pardon Mr. Steese under the circumstances. There was one no vote on that, who was the then sitting Attorney General, who you may know as Adam Laxalt.
Okay, I have two questions. What does it mean, or what is the job of somebody that's clerking for a judge? And the second question is, what is a bench memo that you mentioned earlier?
Good question. Sorry, I'm using lingo and I shouldn't be doing that. So the clerks that I was talking about in my chambers are law clerks. Generally, they are recent law school graduates who take a position as a law clerk for a judge to learn and gain skills and experience, and they help us as justices by doing the research and letting us know what the correct analysis is. They read the briefs in detail, they go through the record in detail, and a bench memo is a detailed memo where they go through, the law clerk prepares them, and it describes in detail the arguments being made by the parties, what happened in the court below, the legal analysis of all of the issues that are raised, and a recommendation for the court on what the outcome should be. So that helps us as justices get kind of a head start on looking at the case when we get that detailed bench memo from the law clerk. And that bench memo will get distributed in our court. It gets distributed to all of the justices that are on that case. So if it's a panel case, it goes to the 3 justices on that panel, or if it's en banc, then it goes to all 7 of us. With the kind of volume court we are, we're not able, as the US Supreme Court does, where they have their chambers works up each case on their own independently, whereas our cases, generally it's one chambers that gets assigned to work it up. Obviously, any of us can go read the briefs and the record ourselves, do independent research or whatever else we want to do, but we do get that bench memo distributed that's prepared by the law clerk. Now, that's different from what's called our court clerk, who's responsible for keeping the records of the court and publishing our decisions in the Nevada reports.
Who is it that writes the decisions? Is that done by your assistants, by your clerks, or do you actually write decisions?
That depends somewhat on the individual justice, how they do things. I generally will have a law clerk take a first draft of it, obviously after detailed discussions with me about what I'm looking for and how it should be analyzed and what our majority that's voted on it, how we want to rule on it, what our reasoning is. But they'll do it initially, and then I do some substantial editing and correcting and making it flow the way I want it to. But I find it helpful to have the law clerk take the first crack at it. I think there may be at least one justice who does more writing from scratch than I do, but that's an individual decision of each.
What's the difference between the job of your assistant and your clerks? What is the assistant's job?
Right. So my assistant has more administrative tasks. She doesn't necessarily have legal training, although she's been an assistant in law offices for many years. I'm lucky to have that experience, but she helps keep me organized. She helps pull all the materials together for our upcoming conferences or arguments, everything that I need to see. She helps make the travel arrangements when we're doing that. She also, though, is part of our internal editing process. We have a multi-layered process to make sure that everything that comes out is correct and accurate the best we can get it. And she is part of that process in terms of checking the citations that are included in what we draft to make sure they're accurate, they're correct page numbers, correct citation of the case, and that the quotation is exactly correct if we have quotations. So she is part of that process as well. But basically kind of as my assistant and help keep me organized. Because I also, besides the pardons board that all of us sit on, we all have other assignments on commissions and committees as well. I sit on the Nevada Children's Commission, the Access to Justice Commission, the Court Improvement Panel, the Judicial Historical Society. And so my assistant helps keep me organized, helps keep my calendar up to date, keep my files organized, things like that.
Is she a lawyer?
She is not. She's been a legal secretary for many years, and she has that. She's really very organized and is good at it. Those administrative tasks, but she does have enough legal exposure that she has a general sense of the legal process.
Does the law require that somebody on the Supreme Court be a lawyer?
Yes. So to be on our state Supreme Court, we have to have at least 15 years as an active member of the bar, as opposed to in district court, they're required to have at least 10 years.
Oh.
And justices of the peace in Washoe and Clark, the populous counties, have to be attorneys for at least 5 years. In the rurals, they don't necessarily have to be lawyers, and many of them are not.
Yeah. And what, well, I can't ask you what you think, but the Lyon County joined a lot of other rural counties in praising their sheriffs for subscribing to the theory that they're the highest authority on the law. Have any cases challenging that concept reached your desk?
They haven't. I don't know, maybe something will come up to challenge what authority the local agencies have in those type circumstances.
Do you think that having judicial experience, having been a judge, is that a big advantage when you reach the Supreme Court?
I think it is. I don't know that it's I mean, it's not mandatory. I don't know that I'm necessarily saying it should be mandatory, but it is helpful for me to have had the experience I had for the years I had in district court, presiding over trials and hearing different kinds of cases. You just, I think it gives you a little bit of a head start to know how things happen as a practical matter in those circumstances. I mean, obviously, if you've practiced before the courts a lot, even if you weren't a judge, you have some of that. But But I do find it very helpful to have had my district court experience, especially on the criminal side, because when I was an attorney before I became a judge, I practiced only in civil. And so, but I've got now substantial experience in both civil and criminal.
You know, when Judge Wilson spoke at the luncheon, we ended up talking a lot about stress. He said, when the district court judges get together every year, handling stress is one of the consistent topics. He said being a district court judge is very stressful and it doesn't stop. You know, every day you got to deal with the same pressures. And is that less of an issue for appellate courts?
I don't think so. I think we still, we also have a lot of stress. I mean, there are some differences. When I was a district judge, because I was presiding over trials and had witnesses and juries coming in directly in front of me, there were some cases that were difficult for me, in particular, child abuse cases or child sex abuse cases. And, you know, when you have those victims coming in and testifying about what happened, or I had a couple of child sex abuse cases where they actually had, the abuser had videotaped themselves, and that was part of the evidence, and that definitely can get to you. It's really hard to unsee some of those things once you've seen them. So in a sense, we're a little more removed as an appellate court because we're dealing with just the briefs and the, you know, the paper record, if you will, and don't have the individuals coming into court who are traumatized by things that have happened to them. So it may be a little less stressful in that way, but we do have, of course, the pressure of making the decisions that govern the state and wanting to get it right and trying to keep up with our pretty large caseload that we have.
When he described the caseload that he deals with, it became obvious to me that they're under-resourced. At least our district courts are. So,
yeah. And like I said, those two district judges here in Carson City end up dealing with a lot of high-profile cases that, like, our other rural counties probably don't. We'd probably have a hard time coming up with a case in the news that came out of the Douglas County District Court or the Lyon County District Court, but these Carson City district judges have all the typical district court type cases, as well as the election related issues and administrative cases, some of which are specifically designated to be heard here in Carson City. So yeah, they deal with a lot. And they get, you know, of course, they're subject to criticism like any of us are, which can be stressful too, but that's, you know, part of being a public servant is you're also subject to public criticism.
That's why we need to make sure our judges have access to good mental health services.
Absolutely.
Yeah.
And those are issues that we talk about. I've been at judge conferences where we've talked about ways of managing stress. And at least, I would say in the last maybe 15 years, I've seen that at conferences, it's more of an issue that's talked about and not swept under the rug. It's still difficult for people who are like hard charging personalities to say, I need to get help, and to admit that you need to get help and you feel embarrassed about it. But we are making resources available and talking more and more about those issues. So at least I think people know that they're not the only one who can feel that way.
I'm really wishing that Alex would throw in a comment or a question because he's spent so much time on this.
I try not to take over other people's interviews. I used to ask a lot of questions, and if you'd like me to, I'll ask one or two.
Please do.
Sure. So I recall Justice Jim Hardesty mentioning at the State of the Judiciary the importance of the judiciary in engaging with the public, educating, and I guess this is an example of that right now. What is your opinion on the level of importance that judges should give to sort of, getting out of their comfort zone a little bit and going on platforms like this, social media platforms even, to communicate and engage with the public?
I think it's really important that we get out and engage with the public. I mean, we're public servants, so it should go without saying. But on the one hand, it is difficult because, as we've been talking about, we're in a unique situation where we can't say as much about issues as perhaps people would like us to. But we need to convey an understanding of our legal system so that I think if people understand the system, they're more likely to respect it and to get the difference between the judicial branch and the other more political branches, that there is an important difference. And we need to maintain, in order for us to maintain our judicial independence, we need people to understand why that's important, why you can't just remove a judge because you disagree with their ruling, and why you can't just remove them because what they say is unpopular, that they have to rule based on the facts and the law. And I think the more that people have that interaction, the personal interaction with folks who sit as part of our judiciary, they get a better understanding, and I think a better respect for the process, which is so important. I mean, I think, I'm going to get on my soapbox here, but I think our whole society relies on respect for the judiciary, because you have to have some trust at some level that if something goes wrong, that the judiciary, when the case goes there, is going to do the right thing. Because if you don't believe that, then why are you going to follow the rules? Why is anybody going to follow the rules if they don't think that the rules are going to be fairly and consistently enforced? And that's our job as judges to do that.
I very strongly have share those concerns of the public's erosion at some level, at least, in the trust in the judiciary and some of the side effects that we see from that. Some of the cases that we're covering are actually eye-opening to the public because they didn't know how technical and detailed the process is when it comes to these hearings and the law. And so I very much appreciate that response. The other question that I had has to go into this misconception that judges have memorized all of the laws. And I was wondering if you could elaborate on the research process, the role that attorneys have in briefing the court, and it's sort of explaining how all of the other pieces of the machine contribute to the decision maker, in this case, the judge.
Sure, right. So of course, no one can know all the law. Now, to be in my position, you should have significant experience in the law and know a lot about it. But even having said that, no one can know it all. And certainly in our position where we're dealing with issues of first impression, meaning issues that have not previously been resolved under our law, no one knows the answer quickly, or it's not necessarily an easy answer to come up with. So we do need the parties to really give thought to how to present the issues to the court, to give us full analysis about any applicable legal authorities, or if we don't have law in Nevada on the subject, to look at other states or the federal law if it's relevant. And I mean, we really couldn't function without the law clerks, like I've mentioned. So each of the justices has 2 law clerks. Plus, we also have a group of staff attorneys who are professionals who work for the court full-time as their long-term job, and they work on specific areas of the law. And they dig deep into some areas and can kind of become experts in some areas. And all of that plays into what happens. And then, of course, all the justices have to talk about the issues together. And I think that makes us better, because some of us may know more about one thing or another thing, but we all have our input. And I think it helps us to be stronger as a team. And at our court, I've really been pleasantly surprised. We get along so well. We don't always agree, of course. Sometimes, discussions can get pretty animated, but everyone is there to try to do the right thing. They're all working hard and want to discuss the facts and the law. And I can tell you that what we're not talking about in our conferences is politics. So
it's good. I've noticed there were a few more dissents popping up than 2020. It's been great following the Supreme Court. I don't want to ask any more questions. I'll let the others take over again.
So Alex, would you explain what your website, what your URL and what it does?
So the Our Nevada Judges organization originally started out by just tracking errors, mistakes judges were made. But in 2019, we expanded into electronic coverage of judicial proceedings, and that's what most people know at this point. I don't usually get questions about the statistics anymore as much as I get questions about the hearings that we record. And so we record hearings in pretty much not every district, but more than half of the districts we have covered. We're starting to get into some of the justice courts. We do embed the videos with a ton of educational information to teach people how the law works with actual real cases. And now we're starting to interview judges. We've interviewed a total of 4 or 5, and these are done through the Perspective series. And it's really just about teaching the public how the judiciary works and helping the public to engage with the judiciary directly. It's more than just one judge or one election or one case. It's one of the things that I like to people to know is that we're trying to become a sort of permanent institution in just continuously educating people on the judiciary, the legal process.
So how many people, do you have any paid staff? Are you?
Yeah. The paid staff are, we do have one researcher, and we do have camera people. We don't use them as much as we used to now that the pandemic has put a lot of the stuff remote, and so that's helping us save money. But we don't, I mean, most of it is volunteer, and that includes my time and my wife's time. But a great question. Thank you for asking that, because one of the things that we're trying to do is at least break even.
So what's the URL?
Our Nevada Judges, exactly how it's spelled, OurNevadaJudges.com.
Here we go. Well, as far as I could ever tell, you're doing a valuable public service.
Thank you.
Okay, well, I wanted to get in a plug for Alex. We managed that.
Yes.
I appreciate it.
I believe I met Alex, was that maybe in 2018 when I was campaigning, maybe a little earlier than that, but I know we've met a few years ago.
I remember that.
Why don't you, if you haven't already, put the URL into the chat. Okay. I don't see any more hands, so maybe we've done justice to this.
I had a question, Ron. It's kind of like, maybe there's not a correct answer to it, I guess. But there is a lot of discussion, or what is the correct arena? Because sometimes court decisions could be 3, 4, or something like that, or 5. So then that decision is really not straightforward. And so sometimes there are, for any argument, there's probably good reasons on both sides. And so people will sit down and shoot him back and forth. But again, an ultimate decision has to be made. And I don't know if that always comes down to the law or if it comes down to feelings. But it's also important to be able to, for me as the public, I guess, to say, okay, I'm trying to understand why you did something, trying to understand what the arguments are, not in a heated or political necessary contact, but being able to understand it. And I don't know what that arena is, because what you said before is, and I agree with you, is that you have to be very careful what you say. But I still have to understand if it's a 4-3, well, yes, the opinions come down and say that, but again, that may not be totally clear either to someone. And I don't know what the right arena is, so that we can maybe have an opportunity to go back and say, no, wait a minute, you know, why did you really think this? Or how did you really go this way? And some of them are social issues that are very hot buttons, and others are just straightforward.
Yeah, I mean, to the extent we're talking about published opinions, and for example, if it is a 4-3 type case, the opinion and the dissent should be explaining the basis for the reasoning and perhaps the basis for the disagreement between them. And although I can see that maybe it might not be clear for a layperson as opposed to a lawyer, but we try. And yeah, I don't, we do our best to try to explain it. But I guess I wouldn't necessarily rely on a newspaper description of a case to really understand it. And I'm not disparaging news people. I respect them very much, but it's just difficult for someone trying to quickly summarize what happened, especially if they don't have legal training. But hopefully our opinions explain the reasoning for our decisions the best we can. It may not be a satisfying answer necessarily, because again, it's a legal decision. It's not a moral judgment or a policy decision. So it's not always a satisfying answer if the outcome isn't one that you would want or would like to see. But hopefully we've at least explained the legal reason for it.
Well, I just thought another one. Roe v. Wade was fundamentally based on the concept that implied in the Constitution was a right to privacy. And then they said, you can't follow this case. So it didn't really establish our rights for anything else. So do we have a right to privacy in Nevada?
We do. Well, I guess that's a multi-part answer. We do, in our Nevada Constitution, first have specific protection of the right to an abortion, and it's in our Constitution. So even if Roe v. Wade got overturned, it would not change that in Nevada there is a right to an abortion. The broader right to privacy, the truth is I would need to look at that. I don't really know for sure off the top of my head. Sorry, I don't know.
I think if we passed a right to privacy, an amendment to the Constitution, it would be half of your work, maybe not yours, but because where do you draw the line? Everybody gives away their everything. You can't go on the internet and not give away your privacy. So I don't know.
That is true. But there's also, many of the rights that we talk about, that we've known about since we were kids, are rights that we have to protect us from government intrusion. That has nothing to do most of the time with private entities. So we have a right not to have, be searched or have your phone searched by the police without them going and getting a warrant. But if we willingly give the right to access our phone to an app that we put on our phone, that's not a Fourth Amendment issue.
Oh my God. Yeah, it would be endless questions like that. And I think we've got them already because we've got the Fourth Amendment.
Yeah.
Anyway.
Yes. And
So
we have that same right against unreasonable searches and seizures in our Nevada Constitution as well. Typically, we interpret it in alignment with how the federal Fourth Amendment is interpreted, but we do have the rights under our state constitution as well.
Well, I never thought of the district courts hearing appeals. This is a new concept for me. So
they get appeals from municipal court and justice court, go to district courts.
Well, that's the whole idea of it never dawned on me. I guess practically all the judges in Nevada, that they're not municipal or justice courts. Every judge in Nevada has appellate experience.
To some extent, yes. Yeah. I mean, some have more than others, obviously, but they do get some of that. They also can get administrative appeals, like denials of unemployment or workers' comp, things like that. I dealt with appeals like that in district court.
So what would you estimate the percentage of the caseload is that is appealing some other decision? Is that
In
a rare,
district court?
is that a, yeah, okay, the district court,
Oh.
how much of their,
I mean, it's probably less than 5% of what they
okay,
do.
well, that's
But it's a
important.
few, yeah,
Okay.
yeah.
All right. Well, I've learned a lot. It's always nice to learn more. And I think everyone would agree with me. It's very valuable contact because we don't get to pick your brain very often. Fortunately, we have elections, so the brain picking has to go on. Of course, you don't have to actually show up at anything like this. You can just go on the ballot and see what happens. But
Well, yeah. Well, I'm happy to have the opportunity to talk to you folks, and if I can help educate and share what we do, that's good. I don't know that now is necessarily the best time, but sometime we could set up to do a little like tour of the courthouse. I could, show you around and show you the courtroom where we have argument here in Carson City. And, it's a nice building with a nice rotunda also, where sometimes groups have receptions and things. So
Justice Hennessy suggested that I organize something like that a few years ago when I happened to run into him, but it never happened. So yes is the answer. I'll try and carry the ball on that, see if I can get a group together. How many would you ideally want?
I mean, in one group, I probably wouldn't want more than like 20 or so. But,
What would be an ideal size? 10, 12?
Yeah, that sounds about right. But
20 seems pretty unruly. Why don't we say 12? Because, we like
Okay.
that. Okay.
We could always do it more than once. If there's multiple, more people that want to come, we can set it up a couple times or every few months or something. I don't know.
Yeah, we talk about it. And how many of us have actually seen all this furniture? I don't know, it'd be a lot more real for me if I could say I'd been there.
Yeah.
Okay. Well, I think that about wraps it up. And we don't really want to go much further, do we? We're already past an hour and a half. So.
Well, I appreciate the opportunity to talk to all of you. Hopefully we'll set up a tour of the Supreme Court building sometime. If you have questions or issues, you can reach out to me. I know you see Howard regularly, and he's not far from me. He's right across the desk. So
Howard was the husband, not the dog, right?
that is correct. The dog is also across the desk from me, but
Well, we were able to talk about Lucifer last time too when Howard was on, the cat.
oh, Satan.
Satan. Oh, Satan.
That's
Okay,
the cat.
close.
Yes, here. Well, he's the lump up there in the cat tree.
Howard was asking for your opinion about dinner. Did you make
Go
a
for
ruling on
it.
dinner?
I can definitively say I am in favor of dinner.
I think you wanted more specifics.
I
But,
made dinner last night.
okay,
It's
so
a
we,
rarity in my house, so this is a positive thing.
And I try and stay on the door.
so anyway, if we're done, we're done. And if I could find the little button, I could hit the button. So why don't you just, when you leave, then I can close the room.
Okay, thanks very much.
You're welcome.
I think if people understand the system, they're more likely to respect it and to